Before we even begin today's courtroom breakdown, buckle up, because this case is a perfect example of what happens when internet activism collides with real courtroom consequences. In this video, a YouTuber who built his reputation filming police and claiming constitutional protections finds himself standing in front of a judge instead of behind a camera. What starts as a routine arraignment quickly spirals into courtroom tension, insults directed at officers, and eventually a verdict that no one in that courtroom could ignore. The big question throughout this case is simple. Where exactly does the line exist between exercising First Amendment rights and interfering with police work? By the end of this hearing, the court is going to answer that question very clearly.
Oh, Jose de Castro? Good afternoon.
Good afternoon, Your Honor. How are you?
I'm good, thank you. All right, Mr. de Castro, this is an obstructing or false info charge. It is case 24-006842. Obviously, I'm going to ask you, you understand your proceedings are being filmed?
Of course.
Okay.
They're here because I'm here.
Right, okay. And just so that the record's clear, you have no objection to that?
Of course not.
Okay.
I would like the transparency. I appreciate
no, that's
it.
fine. I need to ask that. City, there's no other issues for you with respect to this being filmed?
No.
Okay. All right, Mr. de Castro, did you get a copy of the complaint?
I did. The only question I have is who's the prosecutor? What's the prosecutor's name?
Well, let me ask a couple questions and then we'll get into what your questions are. Did you review and understand this?
I don't understand it. I don't understand how I can be charged with obstruction for filming a cop.
Okay.
It doesn't make any sense to me.
So I'm asking a much more basic question. You do not have to agree with this.
Do I understand I'm in charge with the misdemeanor?
Yes.
I do understand I'm in charge
Okay,
with the
that's
misdemeanor.
literally it.
I have trial tomorrow for the exact same thing 1 year ago.
In this jurisdiction?
Yeah.
What we're watching here is the very first step of the criminal court process, the arraignment. At this stage, the judge isn't determining guilt or innocence yet. Instead, the court simply confirms that the defendant understands the charges, enters a plea, and begins scheduling the next phases of the case. Notice how the judge repeatedly clarifies that understanding the charge is not the same thing as admitting guilt. That distinction is extremely important in criminal procedure. Many defendants mistakenly believe acknowledging the accusation somehow weakens their defense. But legally speaking, it does not. It's simply part of ensuring due process. What's interesting here is how quickly the conversation shifts from procedural questions to threats of lawsuits against prosecutors and officers. That kind of rhetoric might play well online, but in a courtroom setting it rarely influences the outcome. If anything, it can sometimes have the opposite effect.
Okay, well, I don't want to get into any of that.
Sure.
Today, we're just here for purposes of this. It's a very procedural type of thing today for the arraignment. So you do understand what you got charged with. You do not have to agree with this. This is just an allegation. So you don't need me to read it to you.
I don't.
Okay, very good. And are you planning on hiring an attorney to represent yourself?
I will have a standby attorney for this case.
You will have a standby
Yes.
attorney. Okay.
Because I think that I'm going to win this easy. It's on film, and I wasn't obstructing anybody.
All right, Mr.
Is this the prosecutor, Matthew B.
Okay,
Walker?
let me do my part first, and then we can get into what it is. So, because I need to know, are you proceeding on your own? Do you want to have an attorney? Because I will give you time to talk to an attorney on your own if that's the route that you would like to go.
I will have a standby attorney for
Okay.
this case.
So typically, I would set this for a pre-trial to give you an opportunity to obtain discovery and for your attorney to find out whatever all is associated with this.
Sure.
So I can set that over for a pre-trial date to give you the opportunity to do that. Would you like to do that?
That'd be great.
Okay. And then what is it that you need to tell me without talking about the facts? Of
I just need to know if this is the prosecutor's name. Is that the person prosecuting, Matthew B. Walker?
That's a good question. I will tell you that the city attorney is Jeffrey Durakat, and that's the person's name on the upper left-hand corner of the complaint. Matthew Walker is a deputy city attorney who actually prosecutes this case. Depends on the office.
I'm going to sue him for malicious prosecution.
Okay.
I'm going to sue everybody involved. I'm going to sue the cops.
So,
I'm going to
Mr.
sue the
Cash,
county.
appreciate you have an opinion. Today's just the arraignment.
I got you.
Saying all these things,
you're
we're
just-
here
you're
for
just
your
kidding.
misdemeanor case.
Sure,
Okay.
but there's a bigger issue. There's transparency in the courtroom, which is the best thing that could possibly happen. Now the people get to hear that I'm going to sue Jeffrey and I'm going to sue Matthew and I'm going to sue every
So
one
here's
of
what
those
we're not
cops.
going to do, Mr. DeCastro. This is not going to be a personal pulpit for your philosophical difference or belief. You have the media here, and that's fine. This
Great.
is an open court. But I don't want you to start saying things too far extraneous for purposes of this misdemeanor charge. Because that's what. No, do not interrupt me. Because that's what we're here for. Okay. So here's the thing. I'm recording everything, and you need to be aware that that's a two-sided thing. You're representing yourself, so I'm having this conversation with you. All these statements that you're saying can also potentially be used against you because you're getting recorded. So just so you understand. So here's what we're going to do. Assuming you're entering a not guilty plea.
Does the misdemeanor carry jail time?
Possibly, yes.
Possible jail time. So you said a second ago that this is a misdemeanor case as though it's something minor, but I can be put in a dungeon and locked away.
Okay. No way.
So that's true.
Did I imply that this was minor by saying that it is a misdemeanor?
It's a big deal.
Okay.
Okay,
Mr.
thanks.
DeCastro, let's not get off on the wrong foot. I have my job to do, and I'm not trying to engage in a conversation that's adversarial with you today.
No, I'm not trying to either. I'm not trying. I like you a lot. I think you look like a real nice person.
Okay.
I got nothing against you personally.
So we're going to enter a not guilty plea on your behalf today.
Thank you.
I'm going to reset this for a pretrial. I do need to understand, because you said you were going to have standby counsel, so are you going to represent yourself primarily, or do you want to have that conversation, come back with your attorney, because there's certain procedural things I'll need to do to protect due process and your due process, if you want to go ahead and represent yourself.
Right. No, I'm going to have a standby attorney, and that has to do with a few different things. But I should probably consult with my attorney before I say anything, because it could be used against me later.
Absolutely. Yeah, that's fine. And I would rather that you protect yourself, because we're recording, and that is where I'm coming from in the kind of conversations and comments that I'm making to you today. Sure. So you are obviously entitled to represent yourself. That is your right. But let's do this. Let's get you a pre-trial date. And that date, ordinary course for private attorney will be
May 1st at 1:30.
May 1st at 1:30?
I think I have.
Do you need a different date?
I may. I may need a different date because I have a different thing in Indiana. I'm just not sure. Can I just look in my phone real quick at my calendar here? And Your Honor, I have absolutely nothing against you. I'm not in any way adversarial to you at all.
Okay, I'm glad to hear that, Mr. DeCastro, because we may be on this case
Yeah,
for
I
a
have
while.
nothing against you. I don't know you. You seem like a nice person to me. I couldn't possibly hold anything against you personally. So I'm just looking for the date that I have in Indiana. I sue lots of cops all around the country. I help sue lots of cops around the country if they violate people's rights. So I have a case in Indiana that I'm just looking for the date. And that May 1st?
Yes, at 1:30.
Can't talk, I'm in court. The judge is looking at me.
Is it easier if I give you a different date and then you look at that?
Well, I'm just not sure if it's May 1st or June 1st. I'm just going to go there because I'm assisting with the financing of filing a federal civil rights lawsuit against these cops who arrested this man for filming cops. So I just want to make sure that I'm there when that happens. It's a lot of work, so he's texting me back right now. I'll know the date in 1 second. I hate to waste any of these people's time at all whatsoever. I just want to make sure that, because then we have to reset it again. If it's possible for my attorney to be here and me not to be here, well then we can set it for any date that's most convenient for the court.
That's fine. You will need to inform your attorney of that date, and then I'm sure they will know to prepare for you. If nobody's there on that day, that would be a problem.
That would be a bad thing.
Right. So you would need to be here if in fact this is not your attorney that you're going to hire, because then I need to figure out, do you need more time? Or
no, I already have an attorney retained.
Okay. So we will keep the May 1st 1:30 date for your standby attorney to appear for you, and you do not need to appear on that date as long as your lawyer is here.
What time is that at, ma'am?
1:30 in the afternoon, and you are in Department 1. May 1st.
Department 1 at 1:30.
Good morning, Agnes Hotel.
Are you Mr. DeCastro? Can you turn off your phone, please? The one that's in your hand.
Just meeting with my lawyer. He's on his way here now. I'm just waiting for him to get there.
All right, I'm gonna wait for your attorney, okay?
Okay.
Thank you.
Thank you.
All right, Jose De Castro, 23 CR 013015.
Good morning, Your Honor. Agnes Botello, is the case of the record. Good morning, State.
Good morning, Mike Lee, on behalf of the defendant, present with me this morning.
So I have signed 2 media requests that permit recording or photographing these proceedings, but I have not granted any other requests to record or live stream these proceedings. So I need Mr. De Castro and everybody else who wants to stay in the courtroom to surrender their phones, or you can leave.
Are your phone covered in now? Take one for you.
I need Mr. De Castro to empty all of his pockets.
What's that?
Empty your pockets
and give up your phone to the judge.
Okay.
I have to give you my phones?
Yeah.
My phones have to be completely off.
Yeah. I don't really want to be part of your YouTube channel. So,
You already are.
great,
You already are.
awesome.
I'm not gonna get into this guy though. I'll get into someone else. I'm not touching
No,
myself.
no, they're gonna go to my marshal.
He's a pig.
Excuse me?
I said he's a pig.
Now this is one of those moments that can dramatically change how a judge views a defendant. Courtrooms operate under strict rules of decorum, and insulting court officers, especially the judge's own security personnel, is something that can immediately escalate the situation. Bailiffs and marshals are responsible for maintaining order and safety in the courtroom, and they are treated as officers of the court. When someone insults them, judges often interpret it as disrespect toward the entire judicial process. Notice how quickly the judge addresses the comment and warns about contempt. Contempt of court is not something judges threaten lightly. It can result in immediate jail time or additional penalties. Even though the defendant apologizes here, the judge has now seen firsthand how he behaves under pressure. And whether people realize it or not, moments like this can influence how judges view credibility, respect for authority, and ultimately sentencing decisions later on.
Sir, I'm not gonna permit you to speak to anybody in my courtroom in that manner. And if you don't want to apologize, I'm gonna hold you in contempt.
I apologize to the court, Your Honor.
No, you can apologize to, they've done nothing to you.
Actually, Your Honor, when you were here, you came over and gave me a directive for no reason and started telling me what to do.
Okay,
I
well,
have all the respect and welcome to the court. I follow the rule of law all the time.
no, it is their job to maintain the safety and security of the courtroom.
I agree with you, Your Honor.
So, if you want to speak like that in my courtroom, I'm gonna hold you in contempt. And if I hold you in contempt, you're going to jail. That is not my wish. Okay?
I wish you would.
All right. So I need you to empty your pockets too. Suit pocket, pants pocket.
This is illegal. This is a violation of my Fourth Amendment.
No, it isn't.
Yes, it is. I don't have any recording devices on me. What are you talking about?
How about your suit jacket?
I don't have anything on me. This is preposterous.
No, it's
This
not.
really is.
No, it's not.
Yes, it is.
Mr. Me, your phone too.
They're recording everything.
They have a media request.
Right, and I'm not recording anything. Is that your guy here took my phone, so his phone's not on.
Right.
Just make sure
You can take the lawyer's phone too.
No, I'm not gonna take the lawyer's phone. He's an officer of the court. All right. Do we have everybody's phones? Are they off? All right. Good. All right. All right. This is the time set for the trial of State of Nevada versus Jose De Castro, 23 CR 013015. Is the state ready to proceed?
Yes, we are, Your Honor.
How many witnesses do you have?
We anticipate one.
All right. Is the defense ready to proceed?
Yes, Your Honor.
All right. I have your request to convert counsel to standby counsel. I'm going to deny that request. Either you represent him or he should have previously requested a Feretta canvas to represent himself. That I just consider that a delay tactic, so that request is denied. Defense, have any witnesses?
Your Honor, I call Jose De Castro.
Okay.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please be seated.
Mr. Castro, before you testify, I'm obligated to inform you that you have the right to testify in this proceeding, but you also have the right to remain silent. And should you choose to remain silent, I may not hold that against you in making my decision. Do you understand that?
I do.
Do you still wish to testify?
Yes, I do.
All right, please go ahead.
You have a YouTube channel?
Yes, I do.
Can you give some insight into what that channel was about?
Objection, relevance.
That's the relevance.
Your Honor, the relevance is that we're presenting a First Amendment defense, and the defendant is a member of the press. There's different standards for First Amendment rulings where there's public policy at issue.
Here we arrive at the heart of the defense argument, the First Amendment. The defense is attempting to frame the defendant's actions as protected press activity, arguing that filming police officers in public is a constitutionally protected form of journalism. And to be clear, courts across the United States have recognized that recording police in public spaces is generally protected under the First Amendment. However, and this is a very important distinction, that protection is not unlimited. The First Amendment does not give someone the right to interfere with an active police investigation or ignore lawful commands from officers during a traffic stop. The court must weigh two competing interests here: the public's right to document government activity and the officer's duty to maintain control and safety during a traffic stop. Determining where that boundary lies is exactly what this trial is about. What do you think? Should filming police always be protected, or should officers be able to restrict it during active stops?
Can give insight into that.
I'm gonna allow it for a bit and see where it goes.
Yes, I do have a YouTube channel, and the reason I have a YouTube channel is because of how many cops kill people every year, how many cops hurt, maim, torture, rape, and kill people every single year. It's such an epidemic that the rest of the world, I get thousands of emails saying, only in America does this happen. I started filming cops because when I was cheated in 2002.
Objection at this point, relevance,
Well, this is the reason I'm a member of the press.
this narrative.
So can you ask him a question?
Yes, Your Honor. What type of films do you make for your YouTube channel?
I only film police in their official capacity. I'm known across the country and across the world.
And why do you engage in that type of film?
So I'm gonna ask you, Mr. Mead, to direct your questions about the incident in question.
The reason I was filming Mr. Gort that day.
Objection, Your Honor. Oh, I'm sorry.
So
There wasn't a question posed, so
Oh, I-
I'm not here what you said.
Mr. DeCastro, on the day in question, why did you approach that vehicle?
I was filming that cop because that's what I do for a living. I am a member of the press, and I invoke my right to be press. I always invoke my right to be press within the first 10 seconds of engaging with police, and I have thousands of videos that prove this.
So this is how you make money.
This is not how specifically I make money. I make money from selling legal documents to people.
Do you recall the officer telling you to back up?
Yes, I do.
And what did you do after he told you to back up?
I took a couple steps back. I just showed him that I was willing to back up a little bit. However, if I may, in Arizona, they created a 10-foot law.
Objection, relevance, we're not in Arizona, it's the state of Nevada.
So I'm gonna allow it because I think that goes to why he kept saying 10 feet in the video, even though I will take judicial notice that you're not in the state of Arizona, you're in the state of Nevada.
Well, a federal judge struck it down, Your Honor, and what?
Stop. Can you ask him a question?
Yes, Your Honor. Approximately how many feet did you back up?
I backed up a foot or two. I was at least 10 feet away from that car that the driver was pulled over in.
And when you spoke to the driver, what did you say?
Just after she was okay. The reason I film police is because they abuse people so often.
Do you recall the officer telling you not to speak with the driver?
Yes,
And did you make any statements to the driver after that command was given?
absolutely not.
Did the officer ever give you a specific distance to back up to?
No, he didn't.
If he did, would you have complied with that?
Sure.
Did you believe you were complying with the officer's command?
100%. I also informed him I'm a member of the press, I'm a constitutional law scholar, but this is what I do.
Do you recall the officer explaining to you why he decided to arrest you?
There's several parts to the reason why he said he was going to arrest me. He said he was going to arrest me because I wouldn't turn my head a certain direction. If I didn't turn and face the car with my head, that he would place me under arrest instead of just giving me a ticket.
Do you recall him explaining why he decided to detain you before he arrested you?
He decided to obtain me because he said I was obstructing, which, from my understanding, is a physical act where I would have to get in the way. He said that the driver deserves privacy. I believe my First Amendment rights are not up for feelings.
Did he explain to you that the basis of your detention was related primarily to the issue of privacy or the issue of you backing up?
Well, I think from the officer's testimony, we can see that he's scared of the driver, scared of me, scared of everything. They teach them to be afraid of everything. So I had 2 cameras out. It's identified as a member of the press. I'm sorry, repeat the question. I want to get it specific for the record.
Sure. The question was, did the officer explain to you that the basis of your detention was because of you not backing up or because of the privacy issue of the driver?
It was both. He said that, he told me to back up. I backed up a little bit. Then he said, she deserves privacy. And then I told him to go get in your car, little doggy, and write your ticket. And at that point, his face turned bead red and his veins in his neck stuck out because we were over 20 feet away. And you had to holler to hear each other because the wind was probably 30 miles an hour.
Did you at any point attempt to hit any of the officers involved?
No, absolutely not.
Did you intentionally swat any of the officers?
Absolutely not. He was giving me unlawful commands. I should not have been detained after I identified as a member of the press. If he ever reached a hand out towards me, I wrestle and teach MMA and I have for 30 years. So it's just a natural reaction as I'm retreating from somebody. If I may have put my hand up, as he said, as he testified himself, I certainly am a law-abiding citizen. I don't break the law. So I would not have tried to assault an officer under any circumstance.
Is it possible that during the interaction there was inadvertent contact between you and the officer?
Sure, he decided to go hands-on with me when he was giving me unlawful commands. And there was absolutely no reason for it. I was willing to comply with anything he asked within reason, because I don't want to have a fist fight with another man on the street.
Do you recall the officer ordering you to go to his patrol vehicle?
I do.
And what did you do in response to that?
Initially, I told him no, but then when he began to get physical with me and start to grab me and touch me, I said, okay, I'll go over to your car. His car was 35 feet away. I then led him to his car. It's on video, you can see it. I walked right up to his car, and then he insisted still on grabbing me. After he saw me pull out an additional phone, which that's what press people do. We have lots of cameras on us.
And did you inform the officer that you were a member of the press?
Oh, several times. It's in the transcripts. I've transcribed them myself. Several times I told him I'm a member of the press.
And did you explain to the officer that you have a background in constitutional law?
Yes, I told him I'm a constitutional law scholar, which was a moniker given to me by other people who are also, they have their own channels, their own press, and that's what some other lawyers on another channel called me 3 years ago. And I since adapted the moniker.
Just to get some, further background, were you looking for police to report on this particular day?
No, the cops hide on the side of the road to pull people over. It's pretty regular in our country. I was just in the parking lot there. I saw that Mr. Bork had somebody pulled over, concerned for her safety. I began to film.
And why do you think that law enforcement traffic stops are relevant to the public?
That's where most people get killed.
Objection relevance.
Staying.
My question, who's your strike?
Staying.
I'll pass the witness, Your Honor.
I have no questions for this witness. Thank you.
Sir, you may step down.
Listen closely to the judge's reasoning here because it explains the legal distinction that ultimately decides this case. The judge explicitly states that filming the police was not the problem. Recording officers performing their duties is generally lawful. The issue, according to the court, was interference. Approaching the driver during an active traffic stop, continuing to engage after being instructed to back away, and inserting oneself into the interaction between officer and driver can cross the line from observation into obstruction. Courts consistently prioritize officer safety and the integrity of the stop itself. A traffic stop is one of the most unpredictable situations officers face, and adding a third party into that interaction, even if they claim to be documenting it, can complicate matters significantly. From the judge's perspective, the defendant wasn't just filming anymore, he was becoming part of the event itself.
All right, Mr. DeCastro, please stand. The problem with the argument that your attorney makes is it completely fails to consider the safety of the officer and the safety of the driver. The officer doesn't know who you are, and the driver doesn't know who you are. And you don't have any right to interfere with that officer doing his investigation and deciding if he wants to issue a ticket to this driver. And you also don't have any business approaching the driver. The driver didn't ask you for help. The driver didn't say, help, help, you know. You didn't see an altercation happening between the officer and this driver. The officer didn't protest that you were filming. There's no problem with filming. You can film, it's fine, all right? But you did interfere with his investigation. You did interfere with his ability to do his job. You did put him in a position where he is concerned for his safety and the safety of the driver. So I believe the state's met their burden beyond reasonable doubt. I'm going to find you guilty of obstructing a public officer and resisting a public officer. So I'd like to hear from the state and then your attorney prior to sentencing.
Your Honor, in terms of sentencing, I would ask the defendant enter and complete an impulse control class. I would ask that the court levy a $500 fine or the equivalent in community service. I would ask that the defendant be ordered to stay out of trouble for the pendency of the case. And I would ask for a 90-day suspended sentence. And that's on as to each count to 1 day current. That's our request.
Thank you.
Your Honor, I'm asking the court to sentence the defendant to credit for time served for these offenses. Even if the court concludes, and the court did conclude that he didn't have the right to do what he did, I think the court can see that he sincerely believed that he had the right to do so. That's based on his past experiences and the training he's received in reference to the First Amendment. I don't think there was any intent from the defendant to engage in any wrongdoing in this case, Your Honor. And that being the case, especially because of the public policy interests at issue.
So when you say he doesn't wish to engage in any wrongdoing, it seems to me from observing him in the video that he wants this. He wants to get arrested. He wants to get into an altercation with the police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called me, and he's nodding his head up and down. So apparently he hates every law enforcement officer in the United States. Please stand up, sir. Are you finished with your request for credit for time served?
I would just emphasize, Your Honor, that the defendant testified and he sincerely believes that he is providing a public service when he reviews and films these incidents. I understand the court may have a different view of that, but when we're talking about First Amendment public policy issues such as supervising people involved in government, I think that is something the court can take into consideration, not to have a chilling effect on that. Let's go on that, Your Honor.
All right, Mr. DeCastro, please stand. I hereby sentence you to 90 days in the Clark County Detention Center on count 1, 90 days in the Clark County Detention Center on count 2, to run consecutive for a total of 180 days in custody. Thank you.
Sentence suspended or?
I'm going to start right now.
You're happy here?
Can I give my keys up? My keys are in the garage. They're in the side. Can you reach up? No, in the briefcase. Yeah. I'll get your stuff. As many mans I thought we place on it. Get a hold of my assistant, James.
And just like that, the court delivers its final ruling, finding the defendant guilty and imposing a total of 180 days in custody. What makes this case particularly interesting is how it highlights the tension between constitutional rights and practical law enforcement realities. The First Amendment absolutely protects the public's ability to document police activity. But as this judge made very clear, those protections do not override lawful commands during an active investigation. Once someone crosses the line from observer to participant, the legal analysis changes entirely. This case also shows how courtroom behavior can influence outcomes. Respect, credibility, and cooperation matter, especially when the judge is deciding sentencing. Now I want to hear your thoughts. Do you think the court got this decision right? Or do you believe the defendant's First Amendment argument should have protected his actions? If you found this courtroom breakdown as fascinating as we did, make sure to hit that like button, share your thoughts down in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one.